Hello students and welcome to the lecture. So students, as we know that we are covering the Panchayati Raj, okay? And these other topics we have scheduled for the discussion under this particular series, like starting with the introduction part, thereafter the evolution of the Panchayati Raj, thereafter the 73rd Amendment Act of 1992, thereafter the compulsory and the voluntary provisions, thereafter the PASA Act of 1996, Extension Act, thereafter finances of the Panchayati Raj, thereafter reasons for the ineffective performance. Okay, so we will continue from where we had left in the previous lecture. Like we have finished the introduction part, we have done with the evolution of the Panchayati Raj. We have been discussing upon the 73rd Amendment Act of 1992. We are left with the compulsory and the voluntary provisions, the PASA Act of 1996, the Finances Act of Panchayati Raj, and the reasons for the ineffective performance. Okay, so let's continue from where we had left in the previous lecture. Okay. Thereafter, basically in the previous lecture, we are discussing upon the Finance Commission of State. Alright. And we had discussed that what are the rules and responsibilities of the Finance Commission of the state, why this was appointed, what recommendation they could make, and other things. So basically, the governor of the state shall place the recommendations of the commission along with the action taken report before the state legislature. Like what are the recommendations the State Finance Commission has made, what actions they could take. Okay. The Central Finance Commission shall also suggest the measures needed to augment the consolidated fund of a state to supplement the resources of the panchayats in the state on the basis of recommendations made by the Finance Commission of the state. All right. After this, the another thing what we have here is the audit of accounts. What does it mean? The state legislature may make provisions with respect to the maintenance of accounts by the panchayat and auditing of such accounts. Okay, like it is also depends upon the discretionary powers of the state legislature. Okay, like they could make the laws if they want to regarding the maintenance of the accounts by the panchayat and how does the auditing of such accounts should be held. All right, thereafter application to the union territories. Like whatsoever the panchayat system we had discussed so far, these are basically for the states. Okay, now let's talk about the UTs, the union territories we have in India. Okay, so the provision of this part are applicable to the union territories. Okay, but the president may direct that they would apply to the union territory subject to such exceptions and modification as he may specify. Why? Because the UTs directly comes under the central government. Okay, so what should be the provisions apply here regarding the Panchayati Raj? That will be directed by the President of India. Okay, so basically, exempted state and the areas from the provision. The act does not apply to the states like the states of Nagaland, the Meghalaya, and the Mizoram. Okay, so here we have got several questions to be formed. First question is which state exempted from reservation provision? The second was which states exempted from provisions of the Act. Okay, so we have got two questions here. So what are the answers of these two questions? Answer 1, answer 2. Okay, let's talk about the answer 1. So basically, the state of Arunachal Pradesh is basically exempted from the reservation provision. Okay, and the states of Meghalaya, Mizoram, and Nagaland. These are those states in which the provisions of the acts not applicable. Okay, and you can say that these are exempted from this. Okay, so there are also certain other areas. So what are these areas? These are the states combinedly. Remember this. Okay, so the other areas are the schedule areas and the tribal areas in the states. Okay, the hill areas of Manipur for which district councils exist, and the Darjeeling district of West Bengal for which Darjeeling Gorkha Hill Council exists. So these are the areas in which the provisions of the 73rd Amendment Act of 1992 does not applicable directly. All right. However, the Parliament may extend the provisions of this part to the scheduled areas and tribal areas subject to such exceptions and modification as it may specify. Under this provision, the Parliament has enacted the provisions of the Panchayat extension to the Scheduled Areas Act 1996, popularly known as the PASA Act or the Extension Act. Okay, so about this, we will have a discussion in the upcoming lecture. Till then, just remember that for these areas, like which are the scheduled areas and the tribal areas, there is nothing like the 73rd Amendment Act of 1992 was not applicable at all. Not this. But yes, there will be some exceptions and the modifications will be provided to these areas as they may be specified. And that will be done under the PASA Act or the Extension Act. And this act was passed in the 1996. 3 years after the implementation of 73rd Amendment Act of 1992. Okay, that's the thing. Thereafter, continuance of existing laws and the panchayats, how they will be related to each other. Okay, like the 73rd Amendment Act of 1992 was passed in the 1992, but we know that after the appointment of Balwant Rai Mehta Committee, various states had already established the system of panchayat. Okay, and they already had the rules and the regulations regarding this. Okay, so what would happen with those existing laws regarding the panchayat system? So basically, when the act was passed, it was said that all the state laws relating to the panchayats shall continue to be in force until the expiry of 1 year from the commencement of this act. It means that the act was passed in 1992, implemented in 1993. So all the acts could be continued till 1994. Okay. Now most of the people conclude that the provision should only continue till 1993 because the act was in the 1992. But it is not the right way. Why? Because it was presented and passed in the 1992. But in 1993, the act was basically commenced. So in 1993, the act was commenced so that the 1994 should be the right answer. Okay. So basically, in other words, the state have to adopt the new Panchayati Raj system based on this act within the maximum period of 1 year. Okay. From 24th April 1993, which was the date of commencement of this act. As I had told you, do not assume the date of 1992 as the commencement year. Why? Because that was only the presented year. The commencement year was on 24th April 1993. It means that the provisions could hardly continue till 24th April 1994. Alright. However, all panchayat existing immediately before the commencement of act shall continue till the expiry of their term unless resolved by the state legislature sooner. Okay, it means that the panchayats which were existing during the commencement of this act, okay, then they should continue till the expiry of their term, whatever term they are left, until unless they will dissolved by the state legislature. Okay, so consequently, majority of the states passed the Panchayati Raj Acts in the 1993 and the 1994 to adopt the new system in accordance with the 73rd Constitutional Amendment Act of 1992. Alright, now let's move forward. Thereafter, bar to interference by courts in the electoral matters. Okay, so the Act bars the interference by the courts in the electoral matters of the Panchayat, declares that the validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies cannot be cautioned in any court. It further lays down that no election to the panchayat is to be cautioned except by an election petition presented to such authority and in such manner as provided by the state legislature. So what happened? That the judicial review power of the courts regarding the elections like delimitation of the constituencies or allotment of seats to such constituencies, this could not be cautioned in any court. Okay, and further lays down that no election to any panchayat is to be cautioned except by an election petition presented to such authority and in such manner as provided by the state legislature. Okay, thereafter the 11th schedule. So basically it contains the following 29th functional items placed within the purview of panchayat. Okay, 29 functional items placed within the purview of Panchayat. First is agriculture, including the agricultural extension. Alright. Thereafter, the land improvement, implementation of land reforms, land consolidation, and the soil conservation. Okay. Thereafter, the minor irrigation, water management, and the watershed development. Thereafter, the animal husbandry, dairying, and the poultry. Thereafter, the fisheries. Thereafter, the social forestry and the farm forestry. Thereafter, the minor forest produce. Thereafter, the small scale industries, including food processing industries. All right. Thereafter, the khadi village and the cottage industries. Then, the rural housing. Then, the drinking water. Then, fuel and fooder. Then, roads, culverts, bridges, ferries, waterways, and other means of communication within that area. Thereafter, rural electrification, including the distribution of electricity. Third is non-conventional energy sources. All right. Thereafter, education, including at the primary and the secondary school, technical training and the vocational education, libraries, cultural activities, markets and fairs, health and sanitations, including the hospitals, primary health centers, and the dispensaries, and the family welfare. Okay. Thereafter, the women and the child development, social welfare, including the welfare of the handicapped and the mentally retarded. Thereafter, welfare of the weaker sections and in particular of the scheduled caste and the scheduled tribes. Public distribution system, maintenance of community assets. Okay, these are the things. After the act, now we have the compulsory and the voluntary provisions. Like we had discussed as earlier, when the 73rd Amendment Act of 1992 passed. So basically, the first thing it did was provided the constitutional status to the panchayats. Second, what they did, that basically they provided the compulsory and the voluntary provisions. Compulsory and the voluntary provisions. So what were these? So let's start the discussion over it. Now we will identify separately the compulsory, like the obligatory or the mandatory, and voluntary, discretionary, or optional provisions and the features of the 73rd Constitutional Amendment Act 1992, or basically the part of 9th of the Constitution. Okay, like what are these? Now here is one thing, let me tell you very very clear, that it is on the repeat, part 9th of the Constitution. I have seen students who often get confused between the Schedule 9 and the Part 9. What is the difference between these two? Let us clear before we go further. Difference between the Schedule 9 and the Part 9 of the Constitution. The Schedule 9 is containing those laws and provisions which could not be bring under judicial review. Okay, containing those laws and the provisions which couldn't be bring under the judicial review. Whereas the Part 9 containing 29 functional items of Panchayati Raj institution. Okay, so that's the difference between the two. Schedule 9 containing those laws and the provisions which couldn't be bring under judicial review in any court. Whereas the Part 9 containing the 29 functional items of the Panchayati Raj institutions as provided by the 73rd Constitutional Amendment Act 1992. Okay, that's the thing. So first is, what are the compulsory provisions? What are the compulsory provisions under this particular act? First is organization of Gram Sabha in a village or the group of village, which is also known as cluster of villages. Now, again, I'm going to ask you the question like, on the basis of cluster of villages, which type of panchayat was proposed to be established? Let me write down so that you could understand it better. On, or you can say, basis of cluster of villages which type of panchayat was proposed to be established. On basis of cluster of villages, which type of panchayat was proposed to be established? Again, I'm going to provide you 30 seconds to think and answer, then I will give you the answer. So, your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. The time's up. So basically the correct answer is Nyaya Panchayat. The Nyaya Panchayat was a type of panchayat which was purposed to be established on the basis of cluster of villages. Okay, that's answer. Establishment of panchayats at village level, intermediate level, and the district level, which means three-tier panchayat. Okay. Thereafter, district elections, sorry, direct elections to all seats in panchayat at village level, intermediate level, and the district level. Okay. But remember that indirect elections to the post of chairperson of panchayat at the intermediate and the district level. Okay. Thereafter, voting rights of the chairperson and the other members of the panchayat elected directly or indirectly will be remain as it is. Okay. It means that there will be no discrimination on the basis of election types. So it could not be held like if the someone who's appointed directly will have the different voting rights, someone who elected indirectly will have the different voting rights. Nothing like this. They both having the same thing. Thereafter, minimum age was fixed at 21 years. 21 years to be the minimum age for contesting the elections to the panchayat. Reservation of seats, both members and the chairpersons for the SC and STs in panchayat at all three levels. Reservation of one-third seat, both members and the chairpersons for women in panchayat at all three levels. Thereafter, fixing tenure of 5 years for panchayat at all levels and holding fresh elections within the 6 months in the event of supersession of any panchayat. Okay. Thereafter, establishment of a state election commissioner for conducting the elections to the panchayat and the constitution of a state finance commission after every 5 years to review the financial position of the panchayat. Okay, so these are the compulsory provision. In the next lecture, we will start with the voluntary provisions. Okay, so students, basically in this lecture, we have finished till here. In the next lecture, we will continue from here. Till then, I request you all, please kindly make sure that you revise all the facts and figures we have discussed in this lecture. Okay, so that you should be prepared for the next lecture. Okay, if you are not doing this, if you are not revising the facts and figures on the regular basis, then the thing will not be so much beneficial for you till your examination. Okay, so try to understand it and kindly revise on the time. So basically with this note, let's end this lecture, and what we say thank you.